Good afternoon. My name is David Brooks from the Insolvency Service. And this afternoon I'm going to cover the COVID support schemes, primarily bounce back loans. These were introduced at fast pace in early 2020, primarily to support businesses meet the challenges of pandemic. But we are now seeing insolvencies coming through, which are indicating some abuse of these schemes. There was the job retention scheme or furlough scheme. There are instances where companies have been claiming for employees who continue to work, who weren't employees at a business, or also overinflated claims. There's also the eat out to help out, self-employment income support, and bounce back loans, which is what we are seeing most of at the moment, and possibly practitioners are as well. The bounce back loans are government backed, and if part of a group, each company could apply. So the main thing is that they're between £2,000 and £50,000, up to 25% of turnover. It was an online application to the bank with self sign off. Standard terms in there were that it was UK based, operating before the 1st of March, adversely impacted by COVID-19, no previous loan, and not already insolvent or otherwise a business in difficulty on the 31st of December 2019. And within those terms, there are several things which are, I think, open to degree of interpretation, which is likely to be causing many of us some problem. One of those issues was the economic benefit. When applying for a loan, the applicant had to confirm the funds would be only used to provide an economic benefit to the business, not for personal business purposes. If funds were used for personal expenses and of no benefit to the business, this could indicate misuse of the loan. When we're looking at economic benefit of the company in our investigations, we're trying to get explanations from the director. How can this loan be shown to have aided the company? Is there evidence of general creditors being paid? How else were these funds used? Where's the evidence? But we are seeing so many cases where typically the loan funds were paid to connected entities, including directors. The bounce back loans sort of take two strands, really. There's first and foremost the application. Was the basis of the application in order and met all terms of the loan? For example, start date, level of turnover. The applicant had to verify when signing off the company's right to the loan and that it met all the relevant conditions. The second aspect is, if the application was correct, then how were the funds used? Did they benefit the company or otherwise? The director should provide evidence to support the use of the funds. One question we have is, how long did the company continue trading when it got those, that particular bounce back loan? Some of the things we're already seeing is that the company was no longer trading, dissolved, about to cease or be struck off. Possible insolvency advice sought, even a CVL set in motion. Turnover of the company misstated, so a higher level of loan fund provided. And far too common is the funds immediately paid to director on receipt with no explanation or evidence of benefit to the company. Payment to directors for their personal benefit is far one of the most frequent things we're seeing. But there are other aspects to this. Have the funds repaid a loan with a personal guarantee? And I have had some debate with people about this as being potentially beneficial to the company, as the bounce back loan terms are more favourable than perhaps some of the other loan terms the company may have had. Possibly used to pay salaries or loans to directors. Were they entitled to them, but also were the payments in line with the previous amounts paid to them pre-COVID? But we are commonly seeing no response or little or any supporting evidence provided by directors, and that's probably the same with practitioners. Some examples of bounce back loans, just plucked from a variety of cases I've looked at. On the 15th of June 2020, the company received a bounce back loan payment of £50,000. 3 days later, £30,000 paid to the director and connected parties. The director has not explained why the funds were paid out or how they were used. In this instance, we're looking at the application and the use. On the 10th of June 2020, the company received £50,000. So the application ought to have suggested a turnover of £200,000 or greater. However, the company's accounts for the year ending 30th of November 2020 detail an annual turnover of £18,000. Now, this could be possibly COVID impacting during the part of that year when COVID had covered half of the year. So the estimate of turnover may well have been correct, and that could be an argument put forward by the director. We shall see. However, on the 22nd of June, so 12 days after the receipt, 2 payments totaling £42,000 were made to the director, part of which he states were used to invest in foreign currency. We obviously want to see the evidence of this and the benefit to the company, this transaction. Where the application seems to have been in order and the funds paid to the company, one of the issues we're finding is that appears to be ongoing trading. So we're not immediately being able to see that funds have then gone out directly or to directors and connected parties. For example, bounce back loan in this one company was taken in April 2020, but looking at the bank statements, they indicate there's a possible continued trading right through to January 21. However, one aspect to this is that the director had substantial drawings each month before and after the loan, pre-COVID and post the COVID situation. So was this business even impacted by COVID? And are the level of drawings justified? So this case, although it would be tagged as a bounce back case, there's more to it than that, because it seems the application was justified and the use of the funds were during the period the company was running. The just concern is, was the director entitled to take out as much as he was? Problem in this case is that the director has now moved abroad. An example where the turnover was incorrect or questionable. This particular application states the turnover in 2019 was £250,000. But the only bank account we've been able to find was opened in March 2020, and the loan paid in on 3rd of June 2020. Funds do not appear to have gone out to the director, but there are nonetheless several questionable payments that the director has yet to explain. With all of this going on, and a number of these cases looking as if there are questionable transactions and inappropriate receipt of bounce back loan funds, the Insolvency Service intends using the compensation regime to enforce recovery in disqualification cases. And if a case is actually a criminal conviction, then the confiscation could well apply. However, if an office holder has managed to make a recovery, that will be taken into consideration depending on the severity of the case and any other potential matters arising as a result of the investigation. Looking at dissolved companies, this is an area where up to now in disqualification we haven't been able to look at these cases, but we're about to see legislation enacted to allow the investigation of dissolved companies for disqualification purposes. What we're seeing is a number of companies which were already dissolved at the time of or shortly after the loan application and the receipt of funds. As there's no office holder, this presents a completely new area of work for the Insolvency Service, and we're gearing up to start to hopefully be able to take this on and look at these cases further. Within this whole area of not just bounce back loans, but the whole COVID financial support, there are other agencies investigating, including Hmrc. The Insolvency Service has a number of criminal cases under investigation, and also companies have been wound up in the public interest by a live investigation team. Just some of the sort of fairly common problems we've encountered. Far too often, directors' whereabouts are unknown. Even they look to have moved abroad or gone back to their home countries. What we're looking for are at least any known email addresses or phone numbers. And there's far too frequently a situation where they're failing to provide evidence or explanations of where the money has gone. We're looking for company records if there are available. So if practitioners do have access to company records, especially those post these loans, that'll be really helpful. Is there a copy of the loan application available? It was online, but it may be possible that practitioners have already managed to get a copy from a bank. And one query is who actually submitted the application, because we have had some directors saying it wasn't them. If you have any questions, please contact me. But otherwise, I'm happy to take questions at the end of this session.
Thank you very much, David. Well, as expected, we do have a number of questions for you on your presentation.
Help.
And some of them I will summarise because we've had questions on a similar vein from a number of individuals. So I will do my best to summarise those. So firstly, just in relation to applications for compensation, so compensation orders within the context of disqualification proceedings, are you seeking compensation orders routinely in every case? And if not, why not?
In every bounce back loan COVID support case, imagine.
I'm thinking, yeah. So specifically, if you're going to go for disqualification on grounds of taking out a fraudulent loan, would it, is it your intention to always seek a compensation order in those cases? Because ultimately, creditors will be wanting to know, can they have their money back?
I think we've been discussing this a lot in the last few weeks, and I'd say always might be a step too far, because we will consider what situation that if it's a CVL, the practitioner reports to us, what they may have settled with the director, or where they have already established there's absolutely no chance of getting any money back for whatever reason. But we want to actively look at where compensation can be obtained. So if we're disqualifying and we need a disqualification to get a compensation order, our intention is to do our very utmost to get that. But as we found with this legislation, and I was responsible for the first case that went through the courts, it's extremely difficult to get money back on it. And we've had a number since then that have just run out of steam as directors declare themselves bankrupt, and it's just that they had no funds. There will be people with funds, and one thing I'm personally keen on trying to do is anything we can do to trace where money's gone. In the one case, Noble Vintners, we took on quite a lot of work and found ourselves where money had gone out of the company to the director. So we did a lot of tracing exercises, and I suggest we would probably be trying to do as much as we can there. Can't guarantee it as it becomes a policy, but I certainly am pushing it a lot as someone who is a bit of a champion for compensation within the organisation, having, as I say, landed the first company. So to answer the question, as much as we can, I certainly want to influence as much as we can do to seek compensation. There will be cases within it that may not be appropriate, as I say, but as a starting point, I'm saying to the investigators I manage, have you looked for compensation? Have you put that to the director? And we want to take that forward as just as much as a disqualification.
Okay. So, you know, in cases where you are successful in obtaining a compensation order, and also in criminal proceedings where you obtain a confiscation order, are the proceeds of those assets then going to go back in the pot for the benefit of the general body of unsecured creditors? How's that going to work?
Well, that's quite fiddly, because the compensation payment relates to the wrongdoing. Now, if the wrongdoing affects a certain creditor or a group of creditors, then the compensation regime has created a new breed of creditor. That was one of the queries about it as it was introduced. It sort of breaks away from the pari passu historical situation. So I would think you'd need to look at the cases. It's not something you could say be general about. I think it depends on the case, the other creditors, but primarily the compensation order is attached to that wrongdoing. So if the wrongdoing is the bounce back loan, I would suggest that the allegation we make that then ties in any compensation will be relating to that bounce back loan, and if the directors move that money. But then the court may have other ideas. Yeah. But this is such a new area now. It's going to present quite a few challenges and questions, and it's for me. I've only started seeing these cases in probably the last 2 or 3 months as they've filtered through to the investigation teams I have. I've looked at several dozen of them and got a good feel of them. And there's going to be we're debating a lot of things within our own organisation, within our own teams, about the nuances of some of the terminology, some of the things in the application, especially when directors push back with explanations that do sort of you have to query some of the terms within the application that make it difficult to give them a bit of a platform to argue a case.
Yeah, okay. You also mentioned HMRC, because I know that they're also going to be looking very closely at some of these situations. Do you anticipate working closely with HMRC? Because I know certainly where we've been acting for office holders, it's quite difficult to get cooperation from HMRC. They like to plough their own furrow. So do you see yourself working closely with HMRC, and how do you think that's going to work?
I can't say we won't. Where there's overlap, I'm sure, with especially perhaps larger, more large scale fraudulent activity, I can't believe we won't do that. Most of the things I'm seeing are single companies, but within HMRC, I certainly try and encourage our teams to work with HMRC and tell them where directors have already been plundering companies anyway, that they might want to have a more serious look at the directors themselves anyway. So I would certainly hope we would, and I know we have picked up some information ourselves already, and there will be other teams, because I just involved with the disqualification teams, but our live investigation teams and criminal teams will be mixing with all sorts of agencies as well. This is a big governmental issue. This is 40 years of working in insolvency, this is the biggest thing I've come across by far. Yeah,
interesting. Okay. All right, I've just had a couple of questions pop up. So there's a question from Paul McConnell, and he says there must be a lot of these, presumably fraudulent bounce back cases. Does the Insolvency Service have a de minimis figure?
In terms of the loan, to be honest, I'm trying not to look at it like that. It's more about the conduct. And that's what I'm trying to influence. But as I say, we're having quite a bit of internal debate about the justification of some cases. We investigate them, but we have teams that will give authority to proceed on them. And we don't always see eye to eye on something like that. But I would maintain it's about the conduct of what someone's done, rather than necessarily the amounts involved.
Yeah, okay.
But then we have quite a pile. And so you're looking at perhaps those that are even more serious up the pile, and sadly some further down might hopefully not fall by the wayside, but there are certainly far more straightforward issues and larger amounts that are worth taking forward.
From a practical point of view and from a manpower perspective, is that likely to be an issue within the insolvency service? Because we all know how widespread this is likely to be. Do you think it's possible that you simply won't have the resources on the ground to investigate all of these cases?
I hope we will, and I hope we will gear up with more, especially as the dissolved company work comes in. That's going to present a very big problem. But at the moment, it's replacing a lot of the work that we would normally have had through our investigation work. Because of COVID, it's sort of caused lots of companies to slow down, or other things brought in, like with Hmrc not petitioning. So that's slowed down, because a lot of our cases do involve failure to pay Hmrc, and that's sort of taken a back seat. This has taken the front seat. So we're doing our best to attack these cases and look at as many of them that come through to our all that come through to our investigation teams. We are really really give it a go.
Right, let me just see what else we've got in here.
I saw one question pop up about using other resources.
Yes, I'm just looking at one for the minute from an anonymous attendee who says, is payment of all other creditor balances using C-bill and B-bill, where the C-bill and B-bill is the only main remaining creditor on liquidation, considered to be for the benefit of the company?
I would argue not. I've literally just been looking at a case that is hit a bit of a skids internally, where similar sorts of things have happened. We're debating this ourselves. Where is is that right? Is that actually, this isn't a commercial lending situation. This is to support the company's ongoing survival. And I personally find some of the attitudes where loans have been left behind, most other things paid, as hard to accept. We push for explanations, but that sort of case then sort of becomes slower, and the directors sort of dig their heels in more when they've done things like that. It's certainly not upscale in terms of just pure plundering, but it doesn't feel quite right within the spirit of how this was intended.
Okay.
I think there's more we need more thought on it. We're only just really getting into this in the last few months.
Yes, sure. We've got a question from Mark Wilson, who says, does the Insolvency Service have enough resources, we've done this, I think, haven't we, to really make an impact in this area, bearing in mind the level of COVID fraud that's being reported, or should it look to utilise the wider insolvency profession?
We are already using firms of panel solicitors that we work with anyway.
Yeah. Okay.
For some, but the volume's still not yet hit, but that, I think we'll be looking at all sorts of options to ensure we can keep on top of this.
I mean, there is going to be an overlap, I think, isn't there, between the work that you're doing and also the work that insolvency practitioners are regularly doing and are expected to do, because they have a statutory duty to do an investigation. And if they find a cause of action, then they should be looking at ways to pursue that with funding if necessary. So to what extent would you be expecting IPs to bring proceedings for misfeasance, breach of duty, wrongful fraudulent trading, where there's overlap between those causes of action and your investigations?
I think it's just traditionally if practitioners were already doing that. I mean, I appreciate in a lot of these cases there's nothing there. They had the bounce back loan as the pure way to get the last bit of money. Hard one to really be definite an answer, to be quite honest. I'd hope if practitioners are picking up this sort of case that they are following it through, because the danger is that it might not be a case for disqualification for whatever reason. But I have had this discussion with practitioners I know already. It's quite a difficult one, and it's always ultimately, is the director going to be able to make a sufficient payment to justify all the costs? We have to bear in mind our costs as well, that we've got sort of strict budgets we work to, which we have to sort of think about how we approach things. The beauty with compensation is And this is why, and one of the reasons in Noble Vintners, the first the sort of case that went to court, we combined it with compensation in that the director wouldn't undertake, and I made a decision though, if we're going to have to issue proceedings, we could just tag compensation onto it. And I could see that it might be, I wouldn't say a sort of cut and paste situation, but if we have to start issuing lots of cases as proceedings, we could well combine the compensation aspect within that. It's just a sort of bit of a off the top of my head type of thought.
Because I think funding is challenging for IPs in many cases, isn't it?
I'm sure. Yeah. Well, it always has been, though, hasn't it?
Yeah, indeed. Yeah. Right. So let me just see what else we've got here. We've got, will any action be taken against loan providers if government-backed loans have been promoted as a way of removing directors' personal guarantees? Action against loan providers? Interesting question.
I've not come across that, and I'm sure someone somewhere would be very keen to look at that. Anything that's, I'd say anything that's caused the impact of this to just worsen. I mean, I couldn't believe today, with this sort of running through my head, I woke up to hear someone on Radio 4 talking about bounce back loans. I thought, am I still dreaming? And of course, I've chosen this day to take part in this when the National Audit Office issued a report that's been, well, we've been blanket coverage of it today. So I think there's a lot more to do here within all sorts of areas of you know, government and other organisations to really look at how this has sort of happened and how people have benefited from it and what could be done.
Okay. We've got another question from an anonymous attendee who says, how does the Insolvency Service envisage that it will take action against directors who dissolved companies following misuse of bounce back loans to recover funds? Would it be via compensation orders or looking to restore and wind those companies up in the public interest, appointing a liquidator to pursue recoveries?
The idea at the moment is to use compensation within those dissolved companies. We're at the moment pathfinding work on the assumption we're going to get this power. So I think anything that we can do to recover money in those dissolved company cases will be looked at. But certainly compensation might be the time it actually comes into good use. Fingers crossed. It's about getting money back somehow.
Well, absolutely, and I think that's what most people are interested, isn't it, in our profession, is getting money back for the benefit of creditors, because that's you know, that's what we're all about. Now, something popped up in the chat from David Butler, which has now disappeared, and I can't find it. So, from me to David Butler, if you'd like to put your question in the Q&A box, then I'll put that to David Brooks. Now, there was something that was in. Got quite a lot of coverage on LinkedIn a couple of weeks ago. And this was a situation where a director had received a government support loan and paid it into an overdrawn bank account, which he'd personally guaranteed. And because that is the rules of the scheme, that's the only place that money can go. Would you be looking at that as a preference, or how would you be approaching that?
Certainly, quite. You know, we'd want to look at it, and that's one. I think that's one of our biggest headache areas. This loan situation, personal guaranteed situation, where there has been the benefit of the director, but I've seen it argued that, well, it might have been a more beneficial terms for the ultimate benefit, economic benefit of the company. I'd say that's probably one of our hardest, most difficult scenarios, and we're trying to pick our way through them. And it might be how we take cases forward. It might even, none of these cases have gone before a court, and that really might be the time where you get sort of decisions on this sort of thing. It's like in the early days of the Disqualification Act, where we were doing things that We may not have done in the same way now to get some case law, to get some understanding of how, does this apply, does that apply?
Yeah, okay. Well, I think with that preference point, one of the issues that arose in the LinkedIn chat that I saw was about desire to refer, and the fact that it's presumed in the case of a director, but of course that's a rebuttable presumption, isn't it? So I think you're right, we'll just have to wait and see how the courts approach that when that argument finally is put and heard by the court.
Without doubt, we some of us take it quite seriously, but you can see there are quite strong counter arguments being made in some cases by directors or their legal representatives.
Okay, well, I'm just looking at the chat box, and I think we've covered everything. And so I'm just going to give it, if anybody wants to ask any more questions, please put those in the Q&A now. I've just got one final point that I wanted to put to you, David, and that was just on this question of economic benefit. And I know that there was a lot of criticism of the government at the time that all of these support measures were put in place, to do with the fact that there wasn't any support put in place for directors of small companies, so one-man companies, very small companies. And I know there's been a lot of debate about, is it or is it not wrong where a government support loan has been taken out and that money's then just been used for the director for what would otherwise have been salary, because the company's not able to trade, it's not able to pay him his salary. But without that director, because in a small company, often that director is the company, it's his knowledge and experience which the company is totally reliant upon. Is that economic benefit to the company if the director takes that money and uses it to keep himself afloat and therefore the company afloat? What's your view on that one? We
have discussed this ourselves because we get quite a few of these, I call them contractor companies, someone working through a limited company. And exactly that point is raised. I need to keep paying myself. I am the company. And if I could just liquidate the company, or I'm trying to work through COVID. I think we have to also not look at this with hindsight, but at the time, it was all it was hugely uncertain. And so not saying being oversympathetic, but you have to put yourself in the shoes of a director. And if someone was paying themselves in a reasonable way at the same sort of level they were, it's feasible. You could say that was that it could be for the economic benefit of the company. It couldn't do anything, but you're right, there was no support for the directors, and so we are seeing quite a number of cases with this, but far too many. They've actually taken out large chunks, and that to me is just, that's not trying to keep the company surviving. But that is again into this sort of pot of difficult areas where I think we've got more to learn and understand about this ourselves, because it is just so new, and we're discussing this so much internally, and there's different schools of thought whether that's right or wrong. It certainly needs good explanation by a director, and we encourage directors to give us those explanations, but sadly all too often they don't, and they certainly don't provide evidence. That's a challenge for us then, because then you're struggling to really know which way to turn, other than say, well, if they're not answering, then they're sort of putting their heads in the noose, perhaps. Evidence is key. I think that applies to everything, doesn't it, in these situations? Yeah. We're struggling badly with getting records and sight of information. We can get bank statements, which sometimes gives you a bit of a clue. I used an example there where I looked at a case where the company had kept trading for a number of months, but the director was paying himself quite handsomely every month, but he had been beforehand. And it just wasn't about taking a bounce back loan money and pocketing a whole lot there and then. It was just within the rest of the company's bank account. So a case like that, I don't quite feel fits the bill. There may be another type of case there, in terms of the level of salary or drawings the director had, in comparison then to not paying one or two creditors. but it's not one you could criticise because of the bounce back loan. So there's more to this, and this is inflating the numbers in a way, because we're seeing CVLs which are tagged bounce back loan, but then when you look beneath the surface, it's, well, there was a bounce back loan, but this is actually not a bounce back loan criticism that we could bring in terms of our final allocation. So we're chipping away at this, day in, day out, trying to find the best way forward in so many strands of it. It's interesting. It is interesting, but sadly, it's a huge loss to the taxpayer.
Indeed, yeah.
Many billions. It's frightening, the numbers I heard this morning.
Well, I think that's why people feel so strongly about it, isn't it? At the end of the day.
Well, then you see other businesses have suffered that haven't had the perhaps access to it, or traded responsibly and still suffered. Whereas there's some of it's organised crime, or just people that found out about it and told everyone in their circle, quick, grab this money, it's free. It's like the story, I think it was about 2 or 3 weeks ago, when a security truck overturned in Los Angeles on the freeway, and people were there was money all over the place, just littering the freeway, and people were asked to give it back. Well, that's not going to happen. It's the same sort of thing here. We've had this situation where there was money that, in desperation to keep businesses afloat, the checks and balances seem to be perhaps not there, and reliant on trust. Perhaps there's a certain risk appetite, but that seems to have been well and truly used and abused.
Yeah.
Following in some of the scenarios I'm certainly seeing.
Well, David, thank you very much. That's been extremely interesting. We don't have any more questions, so I'm going to end it there and say thank you once again.
No problem.
And I'm going to hand back to Caroline, who's going to draw our proceedings to a close. Caroline.
Thank you, Liz, and thank you, David. That was very, very interesting. And also thank you to Ruben for his earlier talk. So as Liz has just said, that brings our conference this year to a close. And I'd like to thank all of our speakers for attending this afternoon and for providing us with such informative and entertaining sessions. Thank you to all of you for attending, and I hope that you've enjoyed this year's event. If I don't get to see you or speak to you again this year, then I don't think I'm too early yet to wish you a very Merry Christmas and a Happy New Year. And I look forward to speaking to you all again soon. Take care. Bye-bye.